Judge, I guess we started out with three things from the county. I don't know if they've given up the good cause argument, but I'll simply argue that good cause existed when the court found it in January of 2016. It still exists, did when Act 156 was applied. We have testimony to support the fact that the lack of ability to find residences statewide is not due to zoning ordinances, but to maybe unintended consequences of Act 156. But I think clearly good cause to proceed outside Racine County existed both previously and today, as there are no viable placements in Racine County. If we're to read Act 156 to require placements in Racine County, this law is unconstitutional. We have to have, when people are appropriate in order to be released, we have to have placements. And the state gets a lot of leeway in determining where they can place somebody statewide. But if we have a law that's interpreted to be that way, the motions will be filed. Secondarily, DHS met their statutory requirements. They filled out a report. You know, we're playing resident. They were looking for everybody in the state, Judge. They testified as to that. That's what the facts are. The Sheriff's Department had notice in March, months ago, about the use of that placement. It says Johnson instead of every possible 980 guy on it, but Exhibit 10 is clear. They asked for input on the residents, and we know they got it because they wrote a report. We gave it to the Department of Health Services back in April. That's also an exhibit in the case. So the local law enforcement knew that there was a 980 guy and knew that they were going into Wheatland, although they may have not known their names. So to say that, you know, that law enforcement didn't get an opportunity, I think is a bit of a stretch. Although I will concede they didn't know the name of every possible placement for the state. Plus, I think what we have to look at this is there was no allegation that they didn't provide notice to the out-of-county individuals and victim witness. Well, they did. They had a core meeting. They met. The DA is here. He knew about it. And his office knew about it. Everybody knew about it. I mean, the real question, I think, in this case is this an appropriate placement because there's a kid next door? I didn't hear much argument about the park. I think clearly Act 156 defines a park. The ordinances, I think, are completely unenforceable because Act 156 says they're unenforceable as the placement of sex offenders. So you can't call Highway 50 or any other road a bike track, or a bike placement. You can't call a river a recreation area or a playground. You just can't do it. If we did that, we'd never place a soul. So is it adequate and appropriate? No placement's perfect, Judge. I'll concede that fact. And it might not be perfect that there's a 1-year-old next door to whatever two individuals are eventually placed in that Wheatland residence, be it by this county or by Milwaukee County or some other county up north. These individuals are going to be placed. And the legislature treated the three different groups of individuals differently. People who offend against elderly victims, they added nursing home restrictions. People who offended against children, they added child buffer zones. For individuals who have been convicted of offenses against adults, there's a different standard. That was just done by the legislature in March. Kenosha doesn't like it, and obviously they don't. Maybe there's an amendment to the law that's coming. That's fine, but the laws as written today, the laws applied by the department, and the law that's being applied in every other county is what's written in 156. This meets criteria. Now, we talked a little bit about things outside the statute and how the department reads people into it, like because of their history or whatever. There's nothing appropriate in Mr. McGee's case to indicate anything, any reaction to any attraction, any intention, any finding of a child victim coming. And the court's already made a finding in the supervised release finding that he's not much more likely than not to reoffend, that he is likely to follow the rules. The state conceded that point and joined in the request. I know they disagree with the placement because they feel that it's not a good one, not based on a legal basis, but based upon the fact that there's a child there. A child there is not a legal basis. The legislature made that clear. So if the court is unhappy with the placement, I think because it is a legal placement, use it as a temporary placement in order for the department to keep looking. Frankly, I don't think it's great that Kenosha does have to take people from other states or that other counties have to take Kenosha people. But that's the reality of the situation as we find it. And if we're order to us to apply the law constitutionally, I think we need to place Mr. McGee. And the court can order DHS to keep looking in Racine. I hope it's not a uniform search. I hope there's placements out there. But one thing I'm relatively confident of is that Mr. McGee can't remain in custody pending the location or creation of a Racine placement. So for those reasons, I've asked the court to find the good cause still exists. The plan is still appropriate. It meets the criteria for Act 156. Mr. McGee be placed within 7 days, and I'll leave it open to the court about temporary or permanent residence.